If you have an immigration court case, an asylum claim, or a family member currently in removal proceedings, stop what you're doing and check your next hearing date today, right now, before you finish watching this video. New federal data just confirmed something genuinely alarming. Immigration judges issued 78,882 removal orders in June 2026 alone, nearly 79,000 in a single month. And during one crowded court session in Texas, most cases that were actually heard lasted less than 5 minutes. But before you panic, I need you to hear something important. This does not mean every hearing across America is now 5 minutes long, and it does not mean 79,000 people were physically deported last month. Tonight, I'm going to walk you through exactly what these numbers really mean, who's actually affected, who isn't, and most importantly, what you need to do right now to protect your own case. Let's start with the real data, because the actual numbers are serious enough without any exaggeration. As of August 3, 2026, here's what's confirmed. This is not a new law. It's not a rule forcing every judge to finish a case in 5 minutes. It's not a nationwide time limit either. What's actually happening is a documented, sustained rise in removal orders, combined with dramatically larger, faster court calendars in specific locations around the country. According to data from TRAC at Syracuse University, judges issued those 78,882 removal orders in June, roughly 30% higher than what was reported back in March. During that same month, 100,773 total cases were closed by immigration courts, the highest monthly total on record, and removal orders made up about 78% of all those closures. Perhaps the most important number in this entire story, 68% of the people who received a removal order were not even present in the courtroom when that decision was made. Here's a distinction that genuinely matters, and I want to be precise about it. A removal order is a legal decision that gives the government legal authority to deport someone. It is not proof that a person was actually physically removed from the country that same day, or even that same month. Some people affected by these orders still have real legal options to reopen their case, and we're going to get into exactly what those options look like later in this video. So let's actually understand how these hearings work, because that context explains almost everything about why this is happening. A master calendar hearing is typically an early procedural hearing. The judge reviews the charges, asks how you respond, explains your basic rights, discusses possible forms of relief, and sets dates for paperwork or a future hearing. These have always been short, and many cases have always been grouped onto the same court session. An individual calendar hearing, sometimes called a merits hearing, is completely different. It's the longer hearing where you actually present evidence, call witnesses, and ask a judge to approve relief, like asylum. The 5-minute reports you may have seen online are specifically about crowded master calendar hearings, not full asylum trials. What's actually changing isn't the type of hearing, it's the size and speed of some of these calendars. On one reported day in Harlingen, Texas, about 90 cases were scheduled in front of a single judge, and most of the cases actually heard that day lasted under 5 minutes. The same day, a judge in Utah reportedly had 159 cases assigned. These are real, documented examples, but they don't prove every single court in the country is running this exact same way. Practice genuinely varies by city, by judge, and by whether someone is detained. Quick pause here, because if you or someone in your life has an active court case, and information like this genuinely matters to your situation, go ahead and hit subscribe and turn on notifications, because we're going to keep tracking this data closely as new numbers come out each month. So who's actually affected by all of this? The people most directly at risk are those who already have an active case in front of an immigration judge. People seeking asylum as a defense against removal. People accused of overstaying their authorized time. People placed into court after entering without inspection. And even some visa or green card holders who've received a notice to appear, the document that formally starts a removal case. Your nationality alone doesn't determine whether this affects you. The real question is whether the immigration court actually has an active case tied to your name, with a hearing already scheduled. And here's something important to understand clearly. If you're simply waiting on a pending application with USCIS, that's a completely separate system from immigration court. A green card holder with no removal case doesn't lose their status just because national removal numbers went up. Someone with a valid work permit doesn't automatically lose it because someone else, somewhere else, missed their court date. But if you personally have an active case in front of a judge, everything we're discussing tonight genuinely applies to you. Here's the first real risk worth understanding: dramatically shorter preparation time. Some people have recently received far less advance notice before a hearing than they were originally told to expect. A hearing that once seemed months away can get moved up with little warning. Picture someone, we'll call him Daniel, who receives a hearing date many months in the future, puts the notice away, and simply stops checking his case regularly. Later, the court moves that hearing forward and mails a new notice. But Daniel never sees it, because he's still mentally relying on that original date. What's confirmed is that courts absolutely can change the date, time, or even the location of your hearing. What's uncertain is exactly how often this happens in any specific city. The safe move is simple. Check your case directly through the official EOIR case status system regularly. Keep every single notice you receive, and if two different sources ever show conflicting information, contact the court or your legal representative immediately rather than guessing. The second major risk might be even more dangerous, because it can happen in a single moment. Missing court entirely, or simply arriving late. If someone doesn't show up, a judge can issue what's called an in absentia removal order, meaning the decision gets made while that person isn't even in the room. The government still has to prove proper notice was given, but the person loses their chance to speak, present evidence, or explain their situation before that order gets entered. Arriving late carries real danger too. Picture a woman, we'll call her Amina, who arrives at the right building on time, but gets stuck in a long security line, then accidentally goes to the wrong floor. By the time she finally reaches the correct courtroom, her name may have already been called. That doesn't guarantee a removal order every single time. Judges do consider the specific facts, but nobody should assume a short delay will automatically be forgiven. Plan for traffic, parking, security screening, and simply finding the right room, and always carry your hearing notice with you. Here's a detail a lot of people genuinely miss. Filing a request does not mean a judge actually approved it. If you file for a change of venue, asking to move your case to a different court, your original hearing date and location remain fully in effect until the judge specifically grants that request. Filing alone doesn't cancel anything. The same logic applies to requests for a remote hearing, more preparation time, or permission not to personally appear. Never stay home simply because you filed a request. Confirm the judge actually approved it first. The third major risk, and honestly, this might be the single easiest mistake to avoid entirely, is your address. Immigration court requires you to report any change of address or phone number within 5 days, using a specific form, EOIR 33/IC. Updating your address with USCIS does not automatically update it with the immigration court. These are two completely separate systems. Imagine someone named Carlos, who moves from Arizona to Illinois, updates his address with USCIS for a different application, and simply assumes the immigration court received the same update. It often doesn't happen automatically. If the court then mails a new hearing notice to his old address, Carlos could miss his entire hearing without ever knowing a new date existed. Each family member may have a completely separate court case, which can mean a separate address form is required for each person individually. Let me walk you through one more complete example because it really shows why all of this matters in real life, not just on paper. Picture a mother, we'll call her Sophia, who's lived in the US for several years, whose kids attend local school, who works and helps pay rent, and who's currently preparing an asylum case before an immigration judge. She believes her next hearing is still many months away. Then she checks the official case system and discovers the court actually moved her hearing forward, and it's now in a different city entirely. She suddenly has far less time to arrange transportation, childcare, time off work, and her paperwork for the judge. Careful planning can't guarantee she wins her case, but it absolutely can prevent mistakes that have nothing to do with the actual strength of her claim. So what should you actually do if a hearing was already missed? An in absentia removal order is serious, but it doesn't always mean every legal option is gone. In some cases, you can file what's called a motion to reopen, asking the judge to cancel that order. This isn't a simple note asking for a second chance. It needs to state a specific legal reason, and usually include real proof. One valid reason is an exceptional circumstance, a serious event genuinely beyond your control, and that type of motion generally must be filed within 180 days of the removal order. A motion can be filed at any time if you can show proper notice was never actually received, or if you were in federal or state custody and missed court through absolutely no fault of your own. Under current rules, removal is generally paused while a judge decides a properly filed motion to reopen an in absentia order, though that pause doesn't guarantee the motion will ultimately be approved. If you find an old removal order tied to your case, speak with a qualified immigration lawyer as soon as possible. Let's quickly correct a few rumors already spreading online. Some posts claim every immigration hearing now lasts under 5 minutes. That's false. The 5-minute reports came from specific, crowded master calendar sessions, not full merits hearings. Other posts claim nearly 79,000 people were physically deported in June. Also false. That number reflects removal orders issued by judges, not completed physical removals. Two very different things. And some claim that missing one court date always means every legal option disappears forever. That's too broad. Some people genuinely can file a motion to reopen based on lack of notice or circumstances beyond their control, though approval is never automatic. Here's the honest, calm bottom line. This update doesn't mean every immigrant is facing immediate deportation. It doesn't cancel every asylum case, visa, green card, or work permit. It doesn't create some new national 5-minute rule. The real warning is that immigration courts are closing cases faster than ever. Some calendars are genuinely overcrowded, and a single missed hearing can result in a removal order before someone ever gets to present their full case. The right response isn't panic. It's simply checking your own case regularly, keeping your address current, saving every notice you receive, preparing early, and getting qualified legal help when your situation gets complicated. Before you go, make sure you've hit subscribe and turned on notifications, because we're going to keep tracking this data every single month as new numbers come out. If this video helped you understand what's actually happening, share it with someone who has an active immigration court case, because right now, accurate information might genuinely be the difference between someone protecting their case and someone losing it over a missed notice. Thanks so much for watching. Stay informed, prepare early, and protect the journey you've worked so hard for.